on the screen here. So with that, then I'll call the Friday, September 18th meeting of the General Laws and Technology Committee to order. Clerk, could you call the roll, please?
Yes, sir. Senator Ruff.
Senator Ruff, you're muted.
Here.
Senator Locke.
Present.
Senator Vogel. Senator Vogel, I think you're muted. Senator Evan.
Here.
Senator Reeves. Senator McPike.
Here.
Senator Donovan.
Here.
Senator Mason.
Here.
Senator Boysko.
Here.
Senator Stewart. Senator Pillion. Senator Bell. Senator Hashmi.
Here.
Senator Kiggins.
Here.
Senator Barker.
Here.
Mr. Chair, you have a quorum.
All right, good. We'll try to move things along here now. Let everybody get an early start on the weekend. We have 7 bills that are before us, and there are 2 that I think we're working out have worked out sort of a path forward on those 2 that were the ones that were a little more problematic. So what we have here are 2 bills that are identical to Senate bills. We'll start out with, can we do those, Clerk, can we do those as a block?
Yes, sir.
All right. We'll do 2 bills as a block. House Bill 5052, Delegate Bagby's bill on legal holidays relating to Juneteenth. And Senator Locke had the identical bill on that. And then the other one is House Bill 5093, Delegate Watts' bill. And it is identical to the bill that Senator Deeds had dealing with emergency services and disaster law, powers and duties of the governor.
Mr. Chairman,
Yes,
would it be possible to take those separately?
certainly it would. Okay, we will separate those. Then we'll start out with the Juneteenth bill, Delegate Bagby's bill.
I would move that we report that.
Second.
All right, we got a motion and a second to report that, which is identical to Senator Locke's bill. Is there any discussion or questions? All in favor, I guess call the roll. We gotta call
Senator Ruff.
Aye.
Senator Locke.
Aye.
Senator Vogel.
Can you hear me?
If we can hear you now.
Okay, thank you. Aye.
Senator Evan.
Aye.
Senator Reeves. Senator McPike.
Senator Reeves is here, is present, but he's muted right now.
No.
Hey, Hobie, I think you know that if you call in and are not able to Zoom, somebody has to go in and do something different for us to let us in, to unlock us from the lockout mute.
Reeves is aye.
Okay, Reeves, aye, all right.
Thank you, and Senator Vogel. IT will look into that. Senator Donovan.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Hashmi.
Aye.
Senator Kiggins.
Aye.
And Senator Barker.
Aye.
Ayes 12.
Mr. Chairman, I'm an aye also.
Ayes 12, no 0.
Okay. All right, thank you. We've got a good start here. Next is House Bill 5093, which is Delegate Watts' bill, and it is identical to Senator Deeds' bill 5117.
Mr.
Chairman.
We report that.
Mr. Chairman, this is Frank.
Yes, Senator Ruff.
I know we didn't do it, and I know we had a lot of discussion on this bill on the floor, but what we're talking about doing is changing law into the future. And any of those who've been around for a while know that sometimes you agree with the governors and sometimes you don't. If this passes, the governor, you won't be able to slow it down without a super majority. So I would offer an amendment to sunset this in 2023.
As of June 30th of 2023.
That would be fine. Whatever day, I don't care what day it is, but I just think we need to rethink this. If there are no problems as we go forward, maybe we can take the sunset off or move it later. But I think we need that sunset, at least for now.
Second.
All right, we have a motion and a second to put a sunset clause on for June 30th of 2023. Is there any discussion or questions on that? All right, Delegate Watts, do you want to respond on that issue?
Thank you, Mr. Chairman, members of the committee. I have confidence that this will stand the test of time, so that I am comfortable with such a sunset. Again, I would emphasize in saying that currently under our misdemeanor as being the only penalty, we're the highest of all of the neighboring states. So that having this option, certainly for the current situation of the pandemic, is very, very important. And as I say, I think it'll stand the test of time, and therefore a sunset provision, I think, is something that will be readily accepted by a future vote of the General Assembly.
All right. Is there any further discussion on this particular issue?
Yeah, Mr. Chairman.
Yes, Senator
Just to
Evans.
clarify with Delegate Watts, we've already passed this bill without a sunset that is heading over to you all in the House. And are you saying you support the sunset or you oppose it?
Mr. Chairman, I would answer that I would accept the sunset because it's 2023. It moves us through our current situation. And what I was trying to express is that the merits of the bill, I don't think will be questioned as we need to reenact in 2023. It will prove itself as being an important option to what is currently the highest penalty of all of our neighboring states, and to be able to instead use a civil penalty that does not put any mark on anyone's record and is handled the same way that a traffic infraction is handled.
Thank you.
All right. Is there any further discussion or questions from committee members? We do have Rita Davis from the governor's office on the call. Do you wish to address this particular issue?
Good afternoon, Mr. Chair, members of the committee. Rita Davis, counsel to the governor. On behalf of the governor, I'm here to express his strong support for Delegate Watts' bill. Thank you, Delegate Watts, for bringing it. But Delegate Watts has very accurately, I think, and proficiently expressed the administration's position on this bill, and the administration defers to her judgment. Thank you, members of the committee, Mr. Chair.
All right. Any other comments or questions as it relates to the amendment? All right. All in favor of the amendment, say aye.
Aye.
Unmute yourself.
Aye.
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 Any opposed, say no. All right. The amendment is adopted.
Move to report as amended.
All right.
Second.
All right. We have a motion and a second to report as amended. Is there any discussion on that matter before we take a vote? All right, clerk, could you call the roll on that?
Senator Ruff,
Aye.
Senator Locke,
Aye.
Senator Vogel,
Aye.
Senator Eben,
Aye.
Senator Reeves,
No.
Senator McPike,
Aye.
Senator Donovan,
Aye.
Senator Mason,
Aye.
Senator Boysko,
Aye.
Senator Stewart, Senator Pillion, Senator Bell, Senator Hashmi,
Aye.
Senator Kiggins,
Aye.
Senator Barker.
Aye.
Ayes 11, noes 1.
All right, that is, it was voted favorably, and we'll now go to the floor on with that one. All right, the next bill we have is one that is similar. This is a bill from Delegate Helmer, House Bill 5050. It is similar to Senator Marsden's bill dealing with Senate Bill 5039, dealing with emergency services and disaster law purchase of PPE equipment. And the Senate Finance and Appropriations Committee has asked for this bill. So if there's a favorable motion on the bill, then it would go forward. It would have to include re-referral to the Finance and Appropriations Committee. Delegate Helmer, you want to present your bill?
Mr. Chair, you've described the bill well. This is the House version of SB 5039, which passed your committee unanimously. This is a bill that allows the governor to purchase PPE on behalf of the private sector during a national disaster or during an emergency declaration, and be reimbursed by the private sector where appropriate for that PPE.
Mr. Chairman, I would move that the bill be reported and re-referred to finance.
Second.
Mr. Chairman,
Yes, Senator McPike.
the differences, there's a couple differences. I think we amended Senator Marsden's bill to require a contract and a few other things. Is there a desire to work that out now, or to just work it out through conference?
We could, well, Senator Delegate Helmer, do you have a response on that?
Mr. Chair, I would answer the senator that you're right. There are a couple of small differences. The House bill adds a requirement that when there's no competition, we just provide a written basis for award. I think the amendments are pretty good. Senator Marsden and I have been very close to this, so we can work it out through conference if
All right.
as you prefer.
Okay.
All right. Anything anybody else wants to say, or any questions from anybody? All right. We have a motion to pass and re-refer to Finance and Appropriations Committee.
And is that going to be to substitute Marsden's language? That way it does go to conference?
Exactly.
Well, that's what it would need to do. Nobody's made that a motion, but if somebody wanted to.
Substitute motion to conform this to Senator Marsden's bill and refer and report to finance.
Second.
Okay. All right, we have substitute motion. Let's, if there's no discussion, let's vote first on the substitute motion. All in favor of the substitute motion, please say aye.
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 All opposed, no. All right, the substitute motion is adopted, so it's the motion that's before us. Is there any further discussion before we take final action on the bill? Okay, clerk, could you call the roll?
Senator Ruff,
Aye.
Senator Locke,
Aye.
Senator Vogel,
Aye.
Senator Eben,
Aye.
Senator Reeves,
Aye.
Senator McPike,
Aye.
Senator Donovan,
Aye.
Senator Mason,
Aye.
Senator Boysko,
Aye.
Senator Stewart, Senator Pillion, Senator Bell, Senator Hashmi,
Aye.
Senator Kiggins,
Aye.
Senator Barker.
Aye.
Ayes 12, noes 0.
All right, that bill is, with the substitute adopted, is reported and re-referred to Finance and Appropriations.
Thank you, Mr. Chair. Thank you, members of the committee.
You're quite welcome. All right, the next bill, which is also a similar bill, is Delegate Price's bill. Well, one of her two bills that are before us today, House Bill 5064, that is similar to Senator Evans' one dealing with the payment plans for tenants who are behind on their payments. So Delegate Price, do you want to present the bill?
Yeah, I'm actually working well with Senator Eben. I would not mind at all if it was conformed to his bill and that we went to conference to work on the final language. It was some minor differences, but we're going after the same thing.
All right. Any discussion or questions?
Mr. Chair, that Senator Evans' bill be the substitute to Delegate Price's bill.
Second.
All right. Okay, we have a motion and a second to conform Delegate Price's bill to Senator Evans' language. There's no further discussion or questions. All in favor say aye.
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 All opposed, aye. All right, that
Move to report.
all right.
Second.
All right, the motion and a second to report this bill as amended. Any discussion or questions? All right, clerk, could you call the roll on that one?
Senator Ruff,
No.
Senator Locke,
Aye.
Senator Vogel,
Aye.
Senator Eben,
Aye.
Senator Reeves,
No.
Senator McPike,
Aye.
Senator Donovan,
Aye.
Senator Mason,
Aye.
Senator Boysko,
Aye.
Senator Stewart, Senator Pillion, Senator Bell, Senator Hashmi,
Aye.
Senator Kiggins,
Aye.
Senator Barker.
Aye.
Ayes 10, noes 2.
All right, the bill is as amended, is reported. All right, we're now into bills that are not of the category of either identical or similar to bills that we had in the Senate. So these are the three that will are a little more extensive here. The first one of those is House Bill 5090 from Delegate Hurst. And Delegate Hurst, you could present your bill now.
Thank you, Mr. Chairman, members of the committee. Before you is House Bill 5090, which would reform Virginia's Freedom of Information Act with regard to criminal incident information and criminal investigative files. A part of what calls us here into special session is to address issues of criminal justice and justice that is either miscarried, delayed, or denied. And we find that all too often in information that is in the case file that a law enforcement agency may have. These can be exhaustive records, sure, and they can have sensitive information. But being able to have a public review of these files will help us to exonerate those who have been wrongfully convicted. And we know that the African-American community is incarcerated at a much higher rate than the rest of the population. We also can use these files to help solve unsolved crimes by allowing for other people to get their eyes on some information to connect some dots that might not have appeared before. And when you think of the fact that clearance rates for victims of crime for minority communities is 20% lower than it is for white victims of crime, that is a reason for us to want to have access to these investigative files. And then when a victim is an African-American or minority and they're shot by police, or a case has happened that they want to be able to have the information as family members, we continue to not allow families and victims themselves to have access to these files so that they can have some understanding and some ownership of what has happened to their loved one, all too often either at the hands of police or without a lot of resolution by police, leading to more questions that cannot be answered. And so just to walk you briefly through the bill starts by changing what is discretionary for release for criminal investigative files and moving it from subsection B up to subsection A. It says that criminal investigative files that have been finally adjudicated or more than 3 years has elapsed from the date the alleged crime was committed, those files are presumed to be required to be released to the public. But we do have some sensitivity with trying to protect rights of victims and also the sanctity of cases, whether they are ongoing or inactive. And we put in there that if a public body engaged in criminal law enforcement activities investigating the alleged crime determines the release will jeopardize the possibility of future prosecution, it may petition to be able to prevent the release of that file. And furthermore, for those who are worried about victim photos or anything that might be graphic or unseemly being submitted to anybody who is requesting, I would point you to what we have further on in line 64 to 67 of the bill, which says that no photograph, audio, video, or other recording depicting a victim shall be identified and released to anybody except the victim, the family if they are deceased, or their parent or guardian if the child is a minor. And so, Mr. Chairman, ladies and gentlemen of the committee, I'll stop here and answer your questions, but the fundamental goal we are trying to achieve here is a justice in our criminal system. And we are doing that here by trying to amend FOIA to say that criminal investigative records are no longer discretionary releases for those law enforcement agencies, which never actually release the files in practice, and saying that no, the public does have a right to know with some safeguards in place so that we can try and actually achieve that justice here in Virginia.
All right. Are there any questions of the patron? Yes, Senator Ruff.
Thank you. Mr. Chairman, Senator Locke has worked very closely with the FOIA Council in the past. Has this been looked at by the FOIA Council at all?
Mr. Chairman, to the Senator, and of course, Senator Locke can also speak to this, but the FOIA Council has looked at this specific issue twice in the last 10 years. In 2011, after Senator Edwards introduced a bill to allow for inactive cases, which is what this is, no ongoing cases, but inactive case files to be released to the public. The FOIA Council looked at that issue, but made no recommendation. In 2016 and 2017, the same issue was brought up again, was looked into again, but because no consensus could be found, no recommendation was made. The real issue here is, I think, a policy question. A lot of the what ifs and the possible scenarios, I think, have been addressed. The real question is up to, I think, policymakers to decide if we want to make this departure, this reform to FOIA. And I think that's why there haven't been recommendations up until now, because it's really up to us to decide.
Mr. Chairman.
Yes, Senator Locke.
And Delegate Hurst is correct. It has been looked at by the FOIA Council in the past without any recommendation coming forward from the council because there was no real consensus on it. But I don't think that precludes the council from taking another look at this issue. But I think we need to continue with some discussion here.
All right. Any other committee members have any comments or questions? All right. Well, we'll go to public testimony then at this time. Clerk, you have people signed up to speak?
Yes, sir. And they are on.
Hobie, would you like me to call those names out?
Yeah, sorry. Took me a second to pull it up.
Okay. Michelle Feldman has the floor.
All right.
Hi. Good afternoon, and thank you for holding this hearing. My name is Michelle Feldman, and I'm the State Campaigns Director for the Innocence Project, and I'm here on behalf of us and also the UVA and Mid-Atlantic Innocence Projects. FOIA law has been a real obstacle to innocence case investigations because agencies can just simply say that they're not going to release files, even when the person has been in prison for a long time and there's no ongoing investigation. And one example is a Norfolk 4 case. There was a police officer who framed 4 innocent people who were later exonerated, but we're unable to get access to the files of other cases that that officer worked on to see if he framed other innocent people. And more broadly, the theme of this special session focus on police accountability. This is really at the heart of that, because police in Virginia investigate officer-involved shootings, and they don't have to turn over the investigative report. So there really can't be confidence that the police are investigating their own properly, and that those incidents are being handled properly without access to that information. And 27 other states have laws that are similar to this proposal that allow for investigative files and completed investigations to be released. And if there are any concerns about it harming a future prosecution or investigation, the agency can go to a court and ask it to enjoin release. So I think this really strikes a balance that the majority of states have, and also the federal FOIA law in protecting ongoing investigations while ensuring the public's right to know is addressed. And as Delegate Hirsch said, there are carve-outs, victims and witness identities cannot be disclosed, and photos can only be disclosed to victims of crime. So it really addresses the concerns that law enforcement had brought up at previous hearings. And I hope that you support it. Thank you.
Mr. Chairman?
Yes, Senator Evan.
Yeah, I have a question about the carve out, if I could ask the witness, or perhaps Delegate Hurst if she doesn't want to respond to it. It had been suggested to me that we consider amending this bill. There's a carve out now about witnesses or victims. How would you feel about if the carve out was expanded to say that no record or photo or audio video of the victim, a witness, or a member of a witness or victim's family would be released to anyone other than the victim or the witness? Would that hamper your efforts in the Innocence Project if it was to become law?
Thank you, Senator, Chairman, to the Senator. I don't think that would hamper our investigations if it was, blocking a photo release. That wouldn't really impact our cases.
Okay, and the bill already does that for photos of the victim. It's just it would add witness, member of the witness or victim's family. So, okay, thank you for that answer.
Sure.
Okay. All right. Do you want to say anything, Delegate Hurst, here, or?
Sorry, I realized I was on mute there for a second. If I may, Mr. Chairman, to the Senator, I would say that I understand exactly where you're coming from. I think that it's important that we try and think about this from a real philosophy standpoint. Having a bunch of exemptions and considerations to make may be well-intentioned, but I think undercuts the premise that we want to say here, which is that an invasion of privacy needs to be unwarranted and needs to be non-justified in order for it to not be in balance with the public's right to know. And we see that with the Fourth Amendment. We see it in other federal applications and court decisions. I just think it's important for us to really remember that that's the foundation, which is that the public has a right to know, and we have to weigh that on balance with people's rights to a privacy. But I think it has to be a clear, credible, unwarranted invasion of privacy, not just the mere happenstance that they happen to be a particular relation to the focus of an investigation or a victim.
Thank you.
All right, Clerk, is there anyone else signed up to speak?
Senator Barker, Jason Nixon has the floor now.
Okay.
Yes, thank you for having me on. This FOIA Information Freedom Act is really important to me, especially with the investigation going on with the Virginia Beach mass shooting. This is the Freedom of Information Act for the people, for the witnesses, to the families. This is not the Freedom of Information Act with discretionary it's a special group, and we want to be included in that special group, especially my wife that was murdered that day. I can tell you right now, her shirt shot. The only reason I have this is because the FBI gave it to me. The bullet holes within the back. Shot there, she shot there, and she shot here. She was shot here in the shoulder, and she called me on a cell phone and told me she'd been shot, called 911. Police came by my house and tried to explain to me what happened, which they were clueless. I had a autopsy report which came out July 15, 2019, and it clearly shows in the autopsy report that Kate had struggled. She had bruises and abrasions on her wrists and hands. So then I went to talk to some of the employees, and they all confirmed with me, yes, Josh and Kate, her coworker, fought the shooter, made him drop his ammunition bag, and that's the reason he had no bullets when he got into the shootout in the corner with the police. Now, that's just one part of it. I can guarantee you this because the acting interim chief, which was Zaccaro, Anthony F. Zaccaro, I was at the Human Rights Commission, and he came to me and Denise, Josh's sister, and confirmed with us that, yes, they did make them drop the ammunition bag, and that's why he had no bullets in the corner. Now, I wouldn't know any of this stuff through the Freedom of Information Act because the City of Virginia Beach, the Virginia Beach Police Department pick and choose what they want to show you and when they want to show it to you. They won't show me the body cameras. They won't show me the pictures of Kate. They didn't even give me the opportunity to identify my wife. My wife. Nobody else's. It's my wife, my family. So what gives them the power to decide what I can see and what I can't see? This is a federal law. This is the Freedom of Information Act. There is nobody within the right power to tell me what my wife went through and what I can see. Strangers have more intimate details on my wife's death than I do. And I think that's wrong. We fought very hard for a state investigation to come through, and it's going to happen. And I'm hoping that we'll uncover a lot of things. But why is it the Freedom of Information Act is so restricted? And why is it they make it so hard? I have an employee from the City of Virginia Beach in 2016 that had a recorded conversation with Dave Hanson, the acting city manager, and she told him, if you guys don't change your ways in the city, things like this are going to happen. I have an email that the city denied that they even had. Kate forwarded that email to me. I leaked it to the press. It says in that email strictly that the shooter felt isolated and confused. All the warning signs were there, but because the Freedom of Information Act withholds this information, I'm not able to get it. What gives that person a right? We don't live in a monarchy. We live in a republic. We're supposed to have the information given to us. We're the people. We work. You guys work for us. We don't work for you guys. This is our right. This is my information of my wife and my family. And I want my children to know that Kate died of heroic acts that day. But I can't prove that until the information act is released. Is it fair? Is it fair that somebody else can know what happened that day and I don't? Why do I have to go behind all the employees and talk to Edwin that had the gun put to his head and says, yes, he walked around him and went straight to Kate and murdered her while Josh and Kate were fighting him? Why is it I have to go through all that? Why can't you guys tell me the truth? I mean, the detectives have not told me one thing. They still have Kate's personal journals, 5 of them, and her iPad. Why are they keeping that stuff? It's my information. It's my property. I paid for those journals, but yet I'm not allowed to have them? I know I sound kind of angry, but I am angry. And I think it's wrong. I think it's wrong for anybody to say, oh, well, it's going to affect the victims and families. Well, first of all, the sheriff's department and the police department don't walk in my shoes. I'm the one that's asking for information. I'm requesting it. And I'm sure there's a safety net there to keep other people from getting information that doesn't need to have that information. But for me, myself, as a family and victim, that information's mine and I deserve it. It's my right. It was my wife, nobody else's. It was my children's mother. And I don't know how to explain this even more passionately than I have, and I can, because this is not right. There's things that go on in the city department. And I'm not saying all police are bad. But I'm saying there's things that go on in the city of Virginia Beach within the police department that they don't want you to know. There's things out there, there's business deals, there's things they don't want to uncover. There's documents that were in Building 2 that day. I'm sure that nobody wanted you guys to see. And I can go on and on about that. So please just take in consideration that the Freedom of Information Act that's what it is. It's the Freedom of Information Act. It's not the Freedom of Information discretionary decide who gets to see what. This is not a special group. We all live in the same country. We're all living in the same rules. There shouldn't be special rules for such special people. The safety nets are there to keep the pedophiles and everybody else, the rapists, from seeing all the information that everybody's so afraid of. There are safety nets there for that to happen. A judge can declare if it's okay or not. If I go to court and ask a judge to give me the information, I should be able to get that information as a father and a husband. That's my right. It's nobody else's. And I'm a big boy. I can handle it. I want to identify Kate. I want to see the pictures because it helps bring closure to me. The only thing I know is when I heard on the police scanner, room 233, deceased. Well, that was Kate's room. She was deceased. And that's how I found out. I just want you guys to take in consideration the importance of this. It's not going to go away. There's too many people out there that need this information. And I'm just a small part of it. This is from my perspective of it. But there's people that are innocently locked up that have files locked in closets because detectives didn't do their job correctly. And that's just, there needs to be a check and balance between that. Somebody needs to be checking the work of other police officers to make sure it's done correctly and it's done to satisfaction of what the law is. And I'm frustrated, and I'm not going to go away, and I'm going to keep fighting for this. And there's another bill I want to fight for is sovereign immunity. I think it's wrong. And a few other things I want to fight for. But right now, this bill is important. This bill is important to my state investigation, so we won't have any roadblocks and tell me what we can see and what we can't see. What are you protecting? The shooter's dead. There's nothing to protect. My wife's dead. There's nothing to protect. Information's there. The truth hurts sometimes, but you need to be able to own up to it and see it. And that's how I feel about it. I'm going to go ahead and let you guys discuss it and talk about it, but I'm not going nowhere, and I'm ready to fight this to the end.
All right, thank you. Thank you very much for your comments and testimony, and sorry for your loss.
Thank you.
Certainly. Is there anyone else signed up to speak?
Senator Barker, you have three more. The next up is Debbie Barato.
All right.
You have the
You're
floor,
on.
Debbie.
Yes, thank you. I appreciate that you're listening today to us. This is a big moment. We've already been through a lot in Richmond as far as hoping to get the state investigation through. My sister as well was a victim, and I agree with Jason. I found out a lot, but I found out through the employees. The police didn't want to talk to me. They avoided me. I've called, they've avoided me, and in a rude way, like we were the criminals. We just want to know what happened. Our families were loved. They were important to somebody. And we need to know what happened to them. And I want to do this for my sister. She deserves that justice. And today, I don't want them to be considered statistics or victims. I want them to be considered as human beings. They were human beings. And the word transparency, I cringe when I hear that word anymore. It's been misused out of context. It's not the transparency, the definition that I'm aware of, because I haven't seen that yet. Although it's been talked about how the police are going to be transparent, how the city officials will be transparent. I'm so sick of that word. And like Jason said, I have a lot of hate in me right now. And I won't quit either until we get what we deserve, what those people died. Those people died. They deserve that. The employees deserve that. What they saw I can only imagine. And for me to live with that in my head is difficult. I can't imagine what they're going through on a daily basis. And today, our whole, I hate everything going on in our world, and I'm sure a lot of you feel the same way, but there's not enough compassion out there. There's right and wrong. I know what's right and I know what's wrong. I try to be on the right side. I grew up and was told to be an honest person, compassionate, helpful, never lie. And I feel like that has all disappeared. And that's all disappeared in my world since May 31st. And I imagine not only my world, but others who have lost their family members to shootings within Virginia Beach and other cities. And we deserve better than that. We're as human as you are. And the only thing today is you have that power to change it. And your power can bring the truth and the justice. And that's what we need. We need a beginning. And if we could just, I don't want to beg for it. I just want what's right. And right now, it's up to you, the senators, to decide what is right. And this bill is right. We need this. The police, even talking to the police won't, they get us nowhere. They treat us, like I said, like we're the criminals. And that's not right. That's just not right. There's other things going on there, reasons possibly that the police can't give it out. I know they have superiors, but we have to break through that wall some way, somehow. And today is the start. So please consider the importance of this. And maybe we can make changes in another city, another Virginia city, or even another state. These people deserve that.
All right. Well, thank you. Thank you very much for your comments. I appreciate it. And sorry for your loss as well.
Thank you.
All
Senator
right.
Barker, the next speaker is Megan Ryan.
Okay.
Thank you, Mr. Chairman and members of the committee. I'm Megan Ryan with the Virginia Coalition for Open Government. And I think it's important to remember that when we're talking about law enforcement here, we're not talking about private security firms. We're talking about the government. Like any others, like a school district or a state agency or a regional authority, law enforcement is the government. Now, FOIA has always given wide latitude to law enforcement to keep track of its records because there has been an understanding that they do sensitive and dangerous work. But there was never an intent to give these government agencies complete cover from review of their work. But that is the situation that FOIA requesters of all types have found themselves in. The situation is that there's near universal denial of any request to see files of cases that are no longer active or pending. And not just any files, but anything from a file. Denial of case files is being done to both the families of victims, as you've just heard, and the families of suspects and the suspects or defendants who have served their terms in prison. I would remind the committee too that just 3 years ago, the General Assembly had to put it in code that the families of suicide and overdose victims were entitled to see investigative files of their loved ones' deaths. You did that, and you did it unanimously because law enforcement routinely and reflexively said no when asked for those records. So the current exemption has ballooned into an all-consuming policy that doesn't even consider whether some or all of a case even needs to have continued protection. So what we're left with is an inability to review the work of government. So I think 5090 tries to strike a balance. On one side, it keeps intact provisions for ongoing investigations. It affords protection for witnesses, respects victim privacy. But on the other side of the scale, it says to law enforcement that, like any government body, you have to be open to some measure of review of your past work. So I respectfully ask that you vote in favor of HB 5090, and thank you for your time.
All right.
Senator Barker, you have one more speaker, and it is Jim Hingley. You have the floor.
All right.
Thank you, Mr. Chair and members of the committee. I'm Jim Hingley, Commonwealth's attorney for Albemarle County. I'd like to start by responding to Senator Evans' suggestion of extending some of the protections and Ms. Feldman's response to that. In House Bill 5090, the release of photographic, audio, video, or other records depicting a victim or allowing for a victim to be readily identified shall not be released except to the victim. Delegate Hurst made the point in terms of expanding that protection to others, that this is something that needs to be carefully considered as a policy matter. I would suggest to the committee that that policy has already been established by the legislature in 19.2-11.2. That's a statute on the books now that says when crime victims' right to non-disclosure of identifying information applies. In that statute, 19.2-11.2, it says that no one may disclose address, telephone number, email address, employment, and so on, identifying information of the witness or victim. I'm reading from the statute: witness or victim or member of the witness's or victim's family. So that policy already exists in law and is good reason for extending it in House Bill 5090 to those classes of individuals beyond victims to include witnesses and members of witnesses or victims' families. Now, I'm also concerned with the interplay between House Bill 5090 and 19.2-11.2. House Bill 5090 says that no records shall be released if the disclosure is prohibited under 19.2-11.2. That's in lines 13 and 14 of House Bill 90. The way 19.2-11.2 works, the protections against those disclosures of identifying information are lifted if there is a law that says that information should be disclosed. House Bill 5090 is a law that in effect overrides, or I would suggest repeals, 19.2-11.2. So that's a very serious concern that House Bill 5090, if enacted, would eliminate the protections that exist in the code under 19.2-11.2. Now, in order to give effect to those protections in 19.2-11.2, you'd have to rewrite that statute. So that's one of the consequences, I think, unintended consequences of passing H. Bill 5090. Now, another thing I would like to point out is that if you can rewrite 19.2-11.2 to cause it to be in effect again, what you have to realize is that it's only in effect when requests are made. That is to say, the protection afforded witnesses, victims, and members of their families are only in effect if they make a request. And up till now, victims and witnesses are not routinely making those requests because the information in the files is confidential, has been up till now confidential. So if you pass a House Bill 5090, there will be, and provide for the general public release of this information, there will be thousands of victims and witnesses who did not make any request and who are now having information about them subject to general public release. So at the very least, if you can reinstate 19211.2, you should be considering some sort of a transitional provision where people who had a chance to request protection and did not do that ought to be excluded from the 5090 disclosure requirements. Another matter that is, I think, worthy of great concern on your part is the definition of criminal investigative files under House Bill 5090 is any documents and information. It's a very broad definition, any documents and information. So let me tell you, just this morning, I did a sentencing in circuit court in which the court and counsel considered a psychosexual investigation and evaluation and a pre-sentence evaluation and investigation. These are documents that, once the case is concluded, are sealed in the court's file. And by sealed, it means they are not open to public access. However, there is no corresponding sealing of those documents in the Commonwealth's attorney's file. So House Bill 5090 would have the effect of requiring the disclosure of information that is maintained confidentially in the court's file, but would be accessible under 5090 when that information is in the Commonwealth's attorney's file. Obviously, you would be aware of what the ramifications of that would be with respect to psychological evaluations and medical records that relate to that. All of that is, again, I think, an unintended consequence, something that might bear some further examination before you proceed to favorably report House Bill 5090. It seems strange that documents which are, for good reason, sealed in the court's file would be open to public access if those same documents appear as they do in the Commonwealth's attorney's file. Another comment that I might make with respect to those sorts of documents, particularly the pre-sentence investigation report, is that has an enormous amount of criminal history information in it, as do other documents that are kept in the Commonwealth's attorney's file, including criminal history reports from VCIN and NCIC. So to the extent that the legislature is now considering expanding expungement in Virginia, please understand that if 5090 goes through as it's currently constituted, then the effect of the expungement, expansion of expungement that the legislature is now considering will be eliminated, because this information about criminal history will be accessible to the general public under Freedom of Information Act requests. Last, going back to Ms. Feldman's concern about access to information on the part of innocence projects and claims of innocence, I believe that this bill could be and should be reworked to allow for targeted expansion of Freedom of Information Act requests, which would include innocence claims and agencies that are working on behalf of people. So my opposition is not to the concept of expanding access, public access to files. in appropriate circumstances. But certainly as it's constituted now, it's going to have a lot of unintended consequences and a lot of access that I don't really believe the legislature would intend to provide to the general public. So a targeted expansion is something that I think is very well worth considering, and also a procedure rather than a general freedom of information release, but some procedure where a court could oversee the release when a showing of good cause is made would be a preferable approach. Thank you again for the opportunity to speak.
Certainly. All right, we've heard public testimony now. The bill is before us.
Mr. Chair.
Yes.
This is Frank. This may be good and very valuable legislation, but this committee has had the policy for a long time to let the FOIA council review and make sure the wording is right on any of these freedom of information proposals. And I think that Senator Locke would agree that even though they did not come to any conclusions in the past, they may well be able to improve the language or make sure that these questions that have arisen in the last 20 minutes are dealt with professionally before we take action on it.
Mr. Chairman?
Yes, Senator Eben.
Yeah, if I can ask, who is the chair right now of the FOIA Council?
I am Senator Eben.
So if I could ask Senator Locke, if it was sent to your commission, do you think that they'd be able to work something out with the wording, come up with something before next session? Or does your agenda allow for that?
Mr. Chairman?
Yes, Senator Locke.
We actually only have two issues that we're dealing with right now. So I think that between now and session, we should be able to put together a work group that can address this issue between now and session.
Thank you, because I think this is a good bill. And aside from the amendment that I raised and the important points the gentleman from Albemarle raised, I would hate to have unintended consequences, particularly if it dealt with sealed records and that the psychiatric evaluations and medical records should be at least considered before we do something we might not intend to.
All right, does anyone want to propose a motion?
Mr. Chair, I move that we gently put this on the table and refer with a letter to create a work group at the FOIA Council. Is that the proper way of?
Clerk, is that a proper motion or is
I think technically the motion is passed by indefinitely with a letter to the council.
With the expectation that we will get this in the proper form so that we can address it in January.
Mr. Chairman?
Yes.
Senator Bell,
Senator Bell.
I want to also let you know I joined the meeting late, but I am here for the vote. Number one. And number two, could we put on that letter a date so we could ask for a reply before the next session, just to add that to it, because I think that it's imperative that we can deal with this in January. And obviously I agree we want to do it right, but if we could add that to that letter, a general suggestion, I appreciate it. Thank you.
I second the motion.
All right, we have a motion that's been made and seconded.
Mr. Chairman, to speak to the motion.
Pass it by indefinitely with a letter to the FOIA Commission, and I think I can communicate well with the chair of the FOIA Commission to try to make sure that we are getting action taken on this. So I don't think that'll be any problem.
Mr. Chairman,
yes.
Speaking to the motion.
Yes.
Thank you, Mr. Chairman. I think this is an incredibly important legislation. Delegate Hurst, you've taken on a really heavy lift, which I think is incredibly important. And I appreciate the work of the Innocence Project, as well as those victims' family members that have joined us on the call today. This is something we've got to figure out. And so what I'd also ask for you, Mr. Chairman, is if the FOIA Council does not have a recommendation, that this committee have a work session on it to go through the findings and information. Again, if there's not a recommendation, so we come to some level of conclusion, since not to say the chairman of the FOIA Council can't work it out. I have confidence in the chair, but just in case there is some level of conflict, I would like the committee's opportunity to review that and make a policy choice for ourselves to be able to move this forward.
Mr. Chairman?
Yes, Senator Locke.
Have confidence in the chair of the FOIA Council.
All right. Is there any further discussion before we vote on the motion?
Mr. Chairman, if I may.
Delegate Hurst.
Thank you, Mr. Chairman. I appreciate the conversation that we were able to have today. A couple of things to keep in mind. Sealed records always trump FOIA, so you can't unseal a record because of FOIA. Medical records are already exempt from disclosure, so psychiatric records, all that stuff, FOIA doesn't trump that. Again, I am happy to continue a conversation where we try to allay fears and walk people through what is what I hope to be, if it's the intent of the body to eventually adopt or make a recommendation through a council to make a reform to FOIA. I just want to remark that how struck I was by the testimony from Jason and from Debbie, and how important it is for us to all realize that when we lose somebody that we love, having a sense of ownership and connection to them takes many different forms and many different shapes. I am so sorry that they have to continually testify now as members of a major incident in our Commonwealth that will never be forgotten. What it underscores for me, though, is all of the people who have family members who continue to feel the exact same way, but their story was never covered in the paper. Their story was never mentioned on the lips of delegates or senators, and yet they want the exact same thing and deserve the exact same thing too. And so again, this is about so many things with regards to criminal investigative files, but in terms of criminal justice, it's about all those that have been denied justice that we never talk about, that I hope we will also keep in mind as we move forward. So thank you, Mr. Chairman, and thank you, members of the committee.
Certainly. All right. Then if there's no further discussion, clerk, would you call the roll on the motion to pass by indefinitely with a letter to the FOIA Council, who has a chair that we can trust?
Senator Ruff.
Aye.
Senator Locke.
Aye.
Senator Vogel.
Aye.
Senator Eben.
Aye.
Senator Reeves.
Aye.
Senator McPike.
Aye.
Senator Donovan.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Bell.
Aye.
Senator Hashmi.
Aye.
Senator Kiggins.
Aye.
Senator Barker.
Aye.
Ayes 13, no 0.
All right, that motion passes, and we'll send the letter to get it to the council so that they can figure out the best way to deal with this and come back with a recommendation, hopefully. All right, and thank all of you for testifying who did. So next bill, our next to last bill is House Bill 5106 by Delegate Joshua Cole. This is a bill dealing with landlord and tenant issues and negative and credit information that is used to in the process of reviewing whether an applicant for a tenancy should be approved. I've had discussions with Joshua Cole and with some of the people who had some concerns, and I think we're heading in the right direction. We have some amendments on things. So at this point, I'll let Delegate Cole sort of summarize things and talk about where we are on this process.
And Mr. Chairman, we have one more bill after this one as well with Delegate Price, correct?
That's correct. That's it.
Thank you, Mr. Chair, members of the committee. HB 5106 provides a needed measure to protect tenants during the COVID-19 pandemic.
ensuring negative credit will not hold back Virginians from accessing housing. The bill will prohibit a landlord who uses a consumer or tenant screening report from taking any adverse action against a tenant or applicant for tenancy, based on any applicant's or tenant's payment history or an eviction for non-payment of rent that occurred from March 12th, the effective date of the governor's issued emergency order, until 30 days after the revocation of the emergency order. And if violated, a tenant will be entitled to recover statutory damages of up to $1,000 plus attorney's fees. Negative credit, because of COVID-19's impact on the economy, should not be a black mark that prevents housing, accessibility to housing. There has been over 27,000 plus eviction hearings and 6,480 families evicted in Virginia since the end of the governor's eviction moratorium this summer. So this measure is a reasonable step to address that loss. And I would just ask it be the pleasure of this committee to pass it on. I know there are some amendments, and I'm open to that as well.
All right. Are there any questions or of the patron?
There are some amendments to be offered. I'd certainly like to take those up.
Yes. All right. Staff, can you summarize the amendments? There are 3 amendments. One, the 2 of them are very simple and straightforward. On line 107, striking the.
Senator Barker, would you like me to read those in for you?
What's that?
This is Council Book. This is Brooks Broad.
Yeah.
Would you like me to read those in, Senator?
Yeah, why don't you read the 3 amendments there? So you're muted now. Brooks, you're there. Okay, now you're.
Can you hear me now?
Yes. Yes.
Yeah, we have 5 total amendments. The first amendment on line 107 of the engrossed bill, after against, strike a tenant or and insert an. On line 107 of the engrossed bill, after on, strike any adverse item related to. On line 112 of the engrossed bill, after determination, strike a and insert, then the landlord shall provide written notice of the denial and the individual's right to assert his failure to qualify was the result of payment history or an eviction for non-payment of rent that occurred during the period beginning on March 12th, 2020 and ending 30 days after the expiration or revocation of any state of emergency declared by the governor related to the COVID-19 pandemic. If the landlord does not receive a response from the applicant within 3 business days, the landlord may proceed with using the information from the report without additional action. If the landlord does receive a response from the applicant asserting such right, and then 4th amendment on line 113 of the engrossed bill, after to the, strike line 113, and then line 119 of the engrossed bill, after subsection the, strike tenant or. That's all.
All right.
Thank you, Mr.
Move the amendments.
All right. The amendments have been moved.
Second.
All right. And they've been moved and seconded. And I have agreed with the patron of the bill, Delegate Cole, to make sure that everything's in line as we're going forward, and that if there's anything that needs to be addressed specifically, we could do that on the floor or later on. So we have the amendments proposed, motion and a second. Is there any further discussion? All in favor say aye.
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 All right. Any opposed say no. All right. Those amendments are adopted. And with that, is there any further questions or discussions on this issue?
Mr. Chairman, this is Frank.
Yes.
I just think we need to make sure that we understand that whenever we put another cost on a business, it's going to be passed on to somebody else. So if hopefully everybody would do what they need to do and there wouldn't be any fines. But if you charge that $1,000 It's going to come out in future either raising the rent or increasing the amount of the deposit. So this has to be dealt with very carefully. So I just warn you of that.
Thank you, Senator Ruff, and that's certainly why we work together, try to make sure that these are narrow and would not provide a major problem here. I did work with with the realtors and with the apartment owners associations in the Commonwealth, and they are in agreement to support the measures going forward with these amendments. They were not ready to endorse the bill without these amendments, and these amendments take care of their significant concerns on this issue. All right, is there any other discussion or questions? All right, is there a motion on the bill?
Move to report.
Report. Second.
All right. Any further discussion? All right, clerk, call the roll.
Sorry. Senator Ruff.
Because I have not gotten notice that people were satisfied, I will vote no.
Senator Locke.
Aye.
Senator Vogel.
For that same reason, no, still.
Senator Eben. I'm sorry, Senator Eben.
I don't.
Aye.
Senator Reeves.
I'm going to abstain.
Senator McPike.
Aye.
Senator Donovan.
I'll abstain until I get word.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Bell.
Aye.
Senator Hashmi.
Aye.
Senator Kiggins.
Abstain.
Senator Barker.
Aye.
8 ayes, 2 nays, 3 abstentions.
All right, motion passes, and we will go to take this on to the floor now.
Thank you, Mr. Chair, members of the committee.
Yes, thank you. Thank you, Delegate Cole. All right, and then the last bill we have, which is Delegate Price's other bill.
Yeah,
House
5115.
Bill 5115. Delegate Price, you're on.
Yes, thank you, Mr. Chairman and members. Very briefly, you've seen this bill before. In 2019, under Senator McPike, we passed temporary legislation that would allow these provisions for furloughed federal workers to give them more time to pay their rent and mortgage to prevent eviction and or foreclosure. And then during 2020 regular session, we passed House Bill 340. It passed the Senate 39-1 that extended those provisions for federal furloughed workers into perpetuity. And then there was a governor's amendment in April at reconvene session that would extend these provisions to those impacted by COVID-19, and that passed the Senate 40-0. This is the exact same thing with just a few changes. Since April, we've been hearing from lawyers, advocates, and tenants and homeowners that the courts were using this provision in various ways. It was not being used uniform based on different jurisdictions. Some were requiring that it had to be 100% loss of income. Some were giving up to 60 days, but also using less than 60 days. And so what this bill does is seeks to clarify the original intent of the legislation by defining affected by to be partial or total loss of income, and stating that it is the 60 full days, 60 days stay or 30 days stay for the homeowner. defining that the emergency is just this current state of emergency for COVID-19, and then also defining what written proof could be used to prove the loss of income. So this also clearly states that it expires 90 days after the emergency order ends. So we've been working on lots of other reasons and ways to prevent evictions. But this, if we clarify it and get it right so that the courts can have a single understanding of it, will especially help those that may rent from excluded landlords or not be eligible for relief and might otherwise fall through that loophole. So the original bill and all the way through has been supported by the Virginia Bankers Association, the Realtors Association, and Virginia Poverty Law Center. I'm not sure if they were able to sign on, but we all work together on this. And so that's the gist of the bill, Mr. Chairman.
All right. Are there any questions of the patron?
Mr. Chairman, this is Frank.
Yes, Senator Ruff.
Delegate Price, if you said any loss of income, even the first dollar?
Yes, Mr. Chairman, and Senator Ruff, I would say yes, partial or total loss of income, yes.
And how would that be verified by the courts?
Yes, so within the bill, there is a list of what constitutes written proof that the tenant or homeowner would have to take to prove to the judge that it has happened. And that's outlined in the bill, so that there is, I guess, a level of proof that has to be shown in order for this to be used within the courts.
Mr. Chairman?
Yes, Senator Evan.
So that's on line 45, Senator Ruff. I believe it says a pay stub that shows the reduced earnings, or a copy of a furlough notification letter, or essential employee status letter from the, or other documentation that the court or the lender finds acceptable.
Thank you, Mr. Chairman. Thank you, Senator Evan, for that response. I don't disagree with the concept, but sometimes people's pay is sporadic, so that you may get paid more this week than you do next week, or this month, or next month. And I just want to make sure that there's no way that this is being gamed in any way.
All right. Any other comments or questions?
Mr. Chairman, I would just like to make a comment speaking to the bill and say thank you to Delegate Price. I have so many constituents. I've heard from hundreds of constituents who are on their last dollar, who are worrying about being evicted, who are not able to hang on. And this is a little ray of hope for them. So thank you for carrying this bill, and appreciate that all the stakeholders work together to get it right.
Okay. Anybody else? Do we have any public testimony?
Yes, sir, Senator. You have 3 people signed up to speak.
All right.
The first one is Matt Bruning.
Good afternoon, Mr. Chairman, members of the committee. Matt Bruning with the Virginia Bankers Association. As Delegate Price mentioned, we've worked with her back in the beginning of the year during the regular session on the underlying bill, and appreciate the efforts to make this a really good process for both the consumers and, in our instance, the lenders. And this clarifying bill, I think, does exactly what we intended to do back in January, so we support the bill.
All right. Who's next?
Next up is Aaron Barton.
Good afternoon, Mr. Chairman. Erin Barton with the Realtors. I'd just like to second Mr. Bruning's comments. We've worked for many months with Delegate Price on this concept. We support what she's doing with the bill and appreciate her including us and working with us on it.
All right.
And you have one more speaker. It's Christy Mara.
All right.
Thank you, Mr. Chairman. Christy Mara with the Virginia Poverty Law Center. And thank you, Delegate Price, for your tireless work on this bill. She not only worked on it during the regular session and then again during the reconvene session, pulling all the stakeholders together and really adding language to address the current pandemic. But then when she heard about the problems and the inconsistencies and how judges were applying the language across the state, which really has, as Senator Boysko alluded to, been causing trouble. We've been hearing about it from our legal aid attorneys handling these cases in every corner of the state. Judges have been treating this right to a continuance differently. So I think this clarifying language is essential to help people exercise their right to that 60-day continuance. And somewhat to Senator Ruff's point, the great thing about this bill is that time is so critical here, especially now that we have the rent and mortgage relief program, because there is funding even for those folks who have had a partial income loss and don't have anywhere else to go. To get those 60 days enables them to get enrolled in that rent and mortgage relief program, which will actually pay the landlord directly whatever the rent amount is that the tenant cannot pay before the continued court date. So we just want to again thank the delegate for bringing this and urge everyone to support this measure.
Mr. Chairman, move the report.
Mr. Chairman, I have a question first. I just want to follow up on Senator Ruff's previous statement because I like this bill and I definitely like the intent, but I just wonder how much the language has been vetted. If you look at line 38, affected by means to experience any loss of income, whether partial or complete. And I agree that could be $1 and there may be limited resources. I want to make sure the people who really need it get them. Is it not sufficient to just say experienced partial or complete loss of income as opposed to any loss? And I just feel like that would at least, to me, I think that you could have structured parameters on this, but at least any loss of income really makes it so dilute.
Mr. Chairman?
Yes, Delegate Price.
Yes, so I think that while I appreciate the concern for gamesmanship, the way that this has been used in courts is by people that have been impacted because of the pandemic. And so whether it is $1 or whether it is a total loss of income, the fact that they're not able to pay their rent and they can show written proof, I think is the guardrails that they need in order to get this stay. There's so much that is happening economically from the constituents that I'm hearing from, not only from the 95th district, but from you all's districts as well, where this is not about someone just trying to game a system. This is people that are having to find totally new jobs because their jobs were wiped out from the entertainment industry or hospitality industry. These are people that are really trying to stay in their homes during an international pandemic so that we don't exacerbate both a health crisis and an economic crisis. So again, this also helps people that are not eligible for some of the rent relief. So these are people that are having to find their own resources and literally are just trying to stay in their homes. And so I think the benefit of the legislation as written outweighs the gamesmanship that may happen. But I'm choosing to stick with the language if possible, Mr. Chairman.
Mr.
Chairman. Mr. Chairman.
Senator Donovan.
Well, just to follow up, I think it's really important that the language of the legislation we pass when it's in code specifically reflects the intent and the goal that we want. And it's not about gamesmanship. It's about deep concern for people who really are in need. And I think that everything you've just said, basically you defined the eligibility as someone who can't pay their rent, but that's not what this says. And I think, I think that the language is not specific enough to achieve the goal that you're looking for. And I think there's a better way to say who's affected. And if you want to say that they can't pay their rent as, related to whatever incident you want to use, I think that's all reasonable and it sets clear expectations. This obscures what you're trying to say.
Mr. Chairman, I would respond and to the senator. Thank you, Mr. Chairman. This actually, the bill that we passed at reconvene had less without the definition of affected by. And so this actually is an attempt to clarify. So when before, when it passed 40-0 and you all supported it, there was no definition of how the income could have been impacted, whether it was partial, whether it was total. So the part of the lines 38 through 42 literally are about whether or not it is partial or complete. So without this definition, it is up to the judge. And there are some judges, specifically from what I've been hearing in Northern Virginia, that any dollar impacted, they counted it. There were some judges in my area where it had to be complete. And so the way that the judges are interpreting it, this definition is trying to get them to do it in a uniform way, saying, if you have had an impact on your income, that you can use this. The fact that they've had an impact on their income and can't pay their rent is why they are in court to begin with, because it's an eviction proceeding. So this is not pre-trial. This is at trial. There has been an eviction, a proceeding that has been started, and this is what they can use in order to get more time, in order to get the money, in order to pay the rent so that they don't get evicted. And so, and I'm sorry if gamesmanship was not your word. I do think that I heard that from the others. So I just wanted to address that concern, even if it wasn't your particular concern.
Mr. Chairman,
Yes,
with infinite respect, I'm just saying, it seems to me it should be either experience any loss of income or experience partial or complete income loss.
Mr. Chairman?
That would clarify the bill to the expressed interest, stated by the patron.
Mr. Chairman?
Senator Evan.
Yeah, I think Senator Donovan is onto something. I'd rather see a bipartisan vote for this bill that has the same impact. And what we're talking about is one word really in effect, which is the word any, depending how you wordsmith the rest of that line on line 38. So we're still talking about, if I'm understanding Senator Donovan correctly, a partial or complete loss of income.
That's what she said, yes.
Yeah, so I don't think that would, unless counsel tells us otherwise, I don't think that would practically hurt the intent of the bill.
So, Mr. Chairman, Senator Evan is suggesting an amendment, which would be to, on line 38, after experience, delete any and insert a. If that seems grammatically appropriate.
Second.
Yes.
Council says yes. No, all right, we have a motion and a second for a very limited, small amendment to the bill. Is there any discussion on that? Anything you want to say, Delegate Price, or at this point, or just proceed along?
I'm good to go. Thank you.
Okay. All right. All in favor of the amendment to strike any and insert a, say aye.
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 All opposed, say no. The amendment is adopted.
Mr. Chairman, I move to report as amended.
All right, we have a motion and a second to report as amended. Is there any further discussion?
Mr. Chairman, just speaking to the motion briefly, I thank the delegate for her good work on this, sort of extending the circumstances which so many Virginians find themselves. And I think clearly we saw courts not take action, as you indicated. And I think this is an incredibly important piece of legislation. So thank you to the delegate, and thank you, Mr. Chairman.
Certainly. All right, any other discussion or questions? All right, clerk, could you call the roll on the motion?
Senator Ruff.
Aye.
Senator Locke.
Aye.
Senator Eben.
Aye.
I'm sorry, Senator Vogel.
Aye.
Senator Reeves.
Reeves votes aye.
Senator McPike.
Aye.
Senator Donovan.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Stewart. Senator Pillion. Senator Bell.
Aye.
Senator Hashmi,
Aye.
Senator Kiggins,
Aye.
Senator Barker.
Aye.
Ayes 13, no 0.
All right. Thank you very much, Delegate Price. And
Thank you, Mr. Chairman and members.
certainly. All right. That completes our docket. So the committee will rise and we'll, I guess, reconvene in floor session on Thursday.